up a little bit around the internet, waiting on Facebook and Twitch and Periscope, but YouTube always takes a little bit longer, and it looks like we're alive and well, so let's get rocking and rolling. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense lawyer here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. And throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and I to follow, but sometimes have a little bit of difficulty doing so themselves. And so that's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our very system with the hope of encouraging some meaningful change. And we're grateful that you are here and with us today. We've got a lot to get into. We're going to start off again by talking about Derek Chauvin. It's trial day 7. We have no new jurors who made it on today, the first day that we've had sort of a strikeout as it comes to new jurors being seated into the jury panel. But we do have some interesting things that took place prior to the jury questioning. Specifically, we're going to talk about the prior bad acts of George Floyd that the defense team is trying to get into court. We spent some time talking about this, and they started to flesh it out a little bit more this morning. And it looks like the judge still is undecided about what to do with this. In particular, I'm talking about a May 5th, 2019 case where George Floyd was also arrested and also sort of went through a situation that was very similar to what we saw in 2020. So we have a little bit of background on that now. We have the defense attorney, Eric Nelson, who gives us some details on it. So we've got some clips from him. We've got some clips from Judge Peter Cahill. And we also have a clip where they're sort of indicating that there's some rumor, the Washington Post reported that there was a judge out of Minnesota who sort of tacitly approved the $27 million settlement. And so Eric Nelson made note of that today, and the judge said, well, that might be fake news. And so we're going to break down what happened there as well. We're also going to talk a little bit about a woman who is no longer with us, rest in peace, Sarah Everard. This story comes from across the pond over in England, in the UK, and a very interesting story that I just sort of caught wind about. And then I looked into it a little bit further. Miss Faith helped bring me up to speed on it. But apparently this woman was a young woman who was kidnapped and then killed by a police officer who is in London, somebody from the Metro PD. So a whole interesting story, a timeline, a series of events that we're going to break down today on the program. So that'll be in the second segment. And then lastly, we're going to talk about H.R. 1, the For the People Act. Last time we talked about this, I couldn't even believe what I was reading because it was so ridiculous. And I mean, ridiculous with a capital R, not even in the realm of something that I would think would be constitutional, but they're still trying to cram this thing through. So it's in front of the Senate right now, and the Democrats know that they really can't get over the Senate filibuster. And so Stacey Abrams and other people are now talking about an exemption or an exception to the current filibuster rules. In other words, the Senate would then go in and have to modify their internal rules and allow this bill, H.R. 1, to skate through even in spite of the existing filibuster rules. So they're going to try to cram this thing through anyways. And so we're going to break down what that looks like. We also have the Arizona Attorney General, Mark Brnovich, who drafted a letter to our senators here in Arizona. I want to show you what that looks like because there's going to be a lot of pushback on this bill, especially if it looks like it's going to pass in the Senate. So we've got a lot that we're going to get into today. Before we dive into it, a couple quick reminders. All of the slides that I'm about to go through are available if you want to download them. We have sources and links in there. That's available over at watchingthewatchers.locals.com, which is a subscription platform where people go and support the show. We're also going to be taking questions in between the segments, and those questions are also asked at Locals. Locals.com, search for the Watching the Watchers group, and you can join us. A lot of great reasons to join up over there. We have awesome people who are posting throughout the day. We have stories and links that are being shared. Grab a copy of my book for free over there, other good stuff. So go check that out at watchingthewatchers.locals.com. All right, so we're going to get started with Derek Chauvin. Day 7 of Derek Chauvin's trial. was well underway today, but we didn't see much progress because they're trying to seat the jury panel, and nobody was added today. We've seen sort of a slow pace, sometimes fast, sometimes slow. We've had 2 get selected, down to 1, a couple of 1 days, but today 0. No additional jurors seated after today's hearings. But we did have some activity taking place early on in the morning where they're still hashing out a lot of issues. Remember, we've spoken about this at the beginning of every day thus far. They've been fleshing out what are called motions in limine, which are the rules for the trial. All of that still has to be established. Yes, there are rules of evidence. Yes, there are rules of criminal procedure, but those are sort of general rules that you have to follow in the trial. Specific to this trial, specific about these witnesses, these expert witnesses, the type of things that people can say during their testimony in the court of law, all of that is subject to modification of rules, and those are being established right now. They're called motions in limine. And yesterday we were talking about this fact that the Minnesota City Council, Minneapolis City Council, settled with the George Floyd family for $27 million right in the middle of the jury selection. And so people are asking, well, how is that fair? Especially if they come out and they say it's the biggest award that they've ever granted for a case like this, something that was national news. They use a lot of language like this was a unanimous decision. If you disagree with that, then maybe you are going against the unanimity of the city council. And so maybe people are thinking that if they're on the jury panel, they might be biased to side one way or the other. So this is a big issue, and it hasn't been settled yet. Today, early this morning, they were hashing this issue out in court. This article comes over from the Star Tribune. I've mentioned they're doing great reporting over there. The judge presiding over the murder trial of Derek Chauvin said on Tuesday he is weighing a couple options. Number one, whether to delay the trial or move the trial in the wake of the city of Minneapolis settling $27 million lawsuit. Payout being made to settle the federal lawsuit brought against the city was announced last week as jurors were being questioned about whether they could be impartial in the trial. Hennepin County District Court Judge Peter Cahill said just before the midday break that he's considering a delay of the trial or having the proceedings moved to another city in the state. He added that he alone will question the 7 jurors on Wednesday, so that's going to be tomorrow, who were seated when the settlement was disclosed at a news conference. He wants to size up whether their ability to be fair to Chauvin has been compromised. And I'm very curious about this line of questioning. Basically, the main question I will have initially is, have any of these jurors even heard of the settlement agreement? Because they're supposed to be sort of not fully sequestered. They're not being set up at a hotel and told to be isolated from everybody and everything, but they are not supposed to go out looking for these stories. And I just kind of want to see how ubiquitous this story has been for them. Are they seeing it on Facebook? Did somebody tell them about it? In other words, what is their media interface looking like right now because they're not sequestered? And if they heard of the settlement, well, that might show you that you kind of have a leaky bucket. You have a bunch of jurors who are not supposed to be obtaining any information about this case, getting information about the case, which might lead to the judge saying, well, we've got no choice but to sequester these people. And that means that they literally get cut off from the rest of the world. It's kind of a tall ask. I don't think anybody wants to go that route. I think the last time, I think we've seen it a number of different times recently, but the big one that I remember, I think, is during the O.J. Simpson case, when I think that they were sequestered for a very long time, and that was a big deal. And so we kind of want to avoid that here, but may not be able to, maybe out of options. If the jurors are supposed to not be getting the news and they're getting the news anyways, what other choice do you have? So that line of questioning is going to take place tomorrow. Cahill said he does not intend to sequester the jury any sooner than when deliberations begin and will not award the defense additional peremptory strikes that can be used to excuse jury candidates. And the reason he said that, so no additional peremptory strikes. So a refresher on that, peremptory strikes are, you can just get rid of a juror without any cause. Typically, you don't want to use those. You want to have the court strike the juror. The judge listens to the same testimony that you, Mr. Defense Attorney, listen to. You want to strike that juror, but you don't want to use your strike because you only have so many strikes. So you ask the judge to strike that person for cause, and you find something in their testimony that shows that they're unbiased, and the court goes ahead and does that. Here, what Eric Nelson was saying is, in order to remedy the improper influence of the settlement agreement, one of his suggestions was that the defense get more strikes so that they can clean up some of the mess left by the settlement. And if people have heard about the case, then he can just strike them. The judge isn't even going to have to consider to strike them for cause because they're going to give him additional peremptory strikes. Well, the judge just kind of looked at that and said, that's a nice request, but if these people are biased, if they're already not able to be impartial, then I'm just going to go ahead and strike them for cause. I'm not going to require you to use an additional peremptory strike. The court's just going to do it on its own motion, on its own volition. So he's saying that he's not going to give them any additional peremptory strikes, probably because he just doesn't think they need them. He knows that this has been a new development and he'll do the striking. He doesn't need to give the defense any additional peremptories. He reinforced that decision Tuesday afternoon when the defense sought but failed to reclaim from the judge one of its peremptory strikes it felt forced to use in the morning when one jury candidate said he heard about the settlement but pledged impartiality toward Chauvin. Before jury selection resumed on Tuesday and ended with no prospective jurors joining those already chosen this past week, the judge expressed exasperation that the city's announcement of the payout came during Chauvin's live-streamed trial. Defense attorney Eric Nelson pointed out that a Washington Post article last week, an unidentified city official said that Chief District Judge Todrick Barnett greenlighted the settlement's announcement. Chief District Judge Todrick Barnett greenlighted the city's announcement, the settlement announcement? So a judge from the courts who's the chief district judge, which might be higher up than the current district judge, Peter Cahill, somebody in the court system, green-lit that in the middle of jury selection? What? That could be problematic. But Judge Cahill says, well, he spoke with Barnett and said what the Post reported, quote, is not an accurate statement. So are you serious right now? The Washington Post posted something that is not accurate? That's ridiculous. Well, so we have a clip of this because it gets a little bit tense, a little bit, not too much, of Eric Nelson bringing this back up to the judge's attention. And you're going to hear him talk about this. He says, I should have brought this up yesterday when we were kind of talking about the settlement agreement stuff, but I didn't. But we did mention this when we were in chambers. And so what chambers means is you're sort of off the record. You go back into the judge's room, into their office, or they have a special room, depending on the court and where you're at. Typically, though, it's the judge's office. So both the prosecutor will go back there, the defense will go back there. Any interested parties will go back. It's not being recorded. It's off the record, and you can actually hash out issues there. And sometimes you can have very good progress in a more informal conference, in an informal meeting place like that. But it's not on the record. And so what Eric Nelson has to do is come back out in court and say, I'm going to make a record about this issue. And he does. And so the judge is kind of up to speed on it. So if you kind of watch the two of them communicating and understanding each other, and you as the audience, you're going, well, I kind of miss what they're talking about. It's because of that. They've already spoken about this issue and now they're rehashing it again. And so hopefully I've laid enough foundation that this makes sense. But this is the conversation taking place specifically about whether a judge in Minnesota greenlit the settlement the settlement agreement, the settlement amount for the $27 million, and specifically said, yeah, go ahead and just release that right now. Release it right in the middle of voir dire of the Derek Chauvin case, which of course is the defendant alleged to have killed George Floyd. That's a big deal if that is true. And so Eric Nelson is bringing that up to the judge's attention, because if that does come out later to be true, if this does result in Derek Chauvin being acquitted, and we later learn that there was some sort of interface between the judiciary, which is the judges and the courts, and the city council, which would be the legislative branch, if there's some sort of collusion there and they're communicating about that, this might be improper, right? It's the court now being lumped in to the perception of bias that the city council, I think, unequivocally clearly laid out when they agreed to that settlement at this particular time. So let's take a look at Eric Nelson. Here he is this morning.
Yesterday, during the course of our hearings and proceedings yesterday, for purposes of the record, relevant to the request for continuance, I neglected to reference the article I did in chambers later, but there was an article in the Washington Post that was published on March 12th of 2021, wherein the Washington Post reports that a Minneapolis official said the city had been concerned that this announcement could affect the trial. The official, who was not authorized to speak.
What was it?
Pardon?
What was it? Okay, go ahead.
Sorry. So I'll just restart, Your Honor. A Minneapolis official said the city was concerned that the announcement could affect the trial. The official, who was not authorized to speak publicly, said the city consulted with Hennepin County Chief District Judge Todrick Barnett, who told the city it could proceed. Barnett did not immediately respond to a request for comment. I think it's just simply for purposes of establishing the record relevant to the motions yesterday regarding the release of that information.
And I don't know if Judge Barnett is clarifying.
I don't know.
That is not an accurate statement. I'm going to leave that to him and
yes.
Dealing with the media. But
But in terms of any of the requests for relief yesterday, I do think it's a question of who made this decision to announce this. So.
And I think the bottom line is this was a federal lawsuit. This court was not involved. And as I recall in my discussions with Judge Barnett, the answer was, we can't tell you what to do. And I think he expressed the concern that we would have about doing such a thing in the middle of jury selection. So there was no approval by this court. We had no authority to approve any release at this time.
I just simply am making a record.
I think the city is trying to try and dump their responsibility back in the court where it does not belong. Nevertheless, it is what it is. We'll deal with it tomorrow.
Thank you.
All right, let's go to our first juror.
All right, so you heard him, not particularly happy about it. So city council, they're dumping their garbage back over here. I'm not calling the settlement garbage, but they're making it our responsibility. They're trying to settle their stuff. They know we're in the middle of this trial. They know we're right in the middle of jury selection, and they did it anyways. So Eric Nelson's making a record, says, hey, just there's a news article about this. Washington Post said one of our judges here in Minnesota greenlit that approval. Judge Peter Cahill turns around and says, well, I don't think that's an accurate statement, but it's for him to clarify that. I'm going to let him come out and address that. He can deal with the media, but we didn't approve it. This court didn't approve it. We didn't have any influence in it. And Eric Nelson just says, "Oh, I know. Just making a record, Judge, because this is going to be a problem down the line," which it very well could be. We don't know how this is going to shake out yet, but they're making a record. They're putting a stake in the ground. This doesn't feel good when you have a judge interfacing with the legislative body, the city council, to green light a $27 million settlement before a jury is even seated in the middle of the jury selection. Okay, it would have been totally different if it was before or after the trial, but it's right in the middle of it. And it feels like it's intentional. So Eric Nelson is bringing it up, and we'll see what the judge does with it. So next up, then, we sort of get through that issue. We are now going to transition a little bit. I've got two long clips. I know they're long, but they're good. There's some good stuff in here that I think is very important. If you are a juror on this case, do not watch this, all right? If you're a juror on the George Floyd case, do not watch this. It's not for you. This is for other people who are interested in what's happening pre-trial, because the trial has yet to start. The jury selection has started, but we have not had opening arguments. And so this is all surrounding a motion in limine, which is establishing the rules for whether or not they can talk about George Floyd's 2019 prior. And so the first clip is going to be the judge who's laying out some background on this. And so before the arguments start, I'm going to show you the judge, then I'm going to show you the defense attorney's argument, a little bit of it. It's a long argument, so he basically goes through four elements. We're only going to take a look at the first element. Then I'm going to read you what the prosecution response is, and then the judge is going to address this tomorrow. So I kind of just ran out of time for all the different clips, so I'm just showing you what I think are the most pertinent clips here. The judge giving some factual background, and then the defense attorney making the argument. It's their motion. Why do they want to get this stuff in? Why do they want to talk about George Floyd in 2019? And there were two cases, right? Obviously, the one in 2020, May 25th, I believe was the date. And that was the one that we all know. But in May 5th of 2019, there was a very similar case, also involving an arrest, also involving the allegedly drugs, also involving some physical difficulties with George Floyd. He had high blood pressure at the time and some other things you're going to hear about. So what the defense attorney, Eric Nelson, is trying to do is he wants to be able to talk about the 2019 case to reference the 2020 case. And he's basically making the case that it is so similar that we can show that there was a modus operandi here, that there was acting in conformity with prior experience. Every time the argument goes, every time George Floyd sees a police officer, well, he freaks out, has a panic attack, says some of the same things, calls out for his mother, calls out that he can't breathe, and so on and so forth. So so they're trying to show a couple things, that George Floyd may not have had difficulty breathing, that this was something that he just says, and we can point to the 2019 case to show that. George Floyd allegedly also ingested drugs at the last minute, which is in conformity with what happened in 2019. And so they're trying to get this in. You can see how powerful this would be. If you could go in front of the jury and say, yeah, no, George Floyd in 2019, the last time that the police knocked on his window, he just ingested everything in his mouth. And that almost killed him back then. It didn't. Yeah, he got medical treatment and he survived that, but he did the same thing again in 2020. And therefore, we're going to make the argument, or we want to show you the 2019 case to make the argument that supports that that's what happened again in 2020. So you can see that would be very, very provocative, I think. I think a lot of people on the jury would go, oh, wait a minute, that's what he does? Anytime the police come up, he just ingests whatever drugs he has on him. Well, that would lead you to believe that maybe it wasn't a knee on the neck that was the ultimate cause of death. It was, in fact, the drugs finally being processed by the body. And if he consumed them right about the time that the officer was knocking on the door, and he was basically dead 9, 10, 11 minutes later, you could process that maybe or make the argument, whether an expert witness will come in and testify to this, I don't know, but make the argument that what ultimately caused the death was the body processing the drugs that gave him the cardiac arrest that resulted in his death. So that's what we're talking about here. Whether the 2019 case can come into play. Judge, quite frankly, doesn't seem to buy it, doesn't seem to think that it's relevant, and he's going to explain some of that right here. So hopefully I framed that out enough. Here is Judge Peter Cahill giving us some background on the prior bad acts for George Floyd. Here it is.
Provided more information to the court. I'd just like to review where we are at. Originally, the state had filed a notice of intent to introduce this as additional evidence. And specifically, and this is going back to August 28th motion, that Mr. Floyd was engaged in the sale and possession of large quantities of controlled substances. When approached by police, he placed drugs in his mouth in an attempt to avoid arrest and swallowed them. And when interacting with police, he engaged in diversionary behavior such as crying and acted irrationally. Point number 2, that when he was under arrest, he was fearful because of being accused of selling drugs and for abusing opiates. And then number 3 is unrelated. That's not the May 6th. At the time of our motion hearing in September, the court reviewed some body-worn cameras from the officers at the scene right up until the police station. And at that time, I granted the state's motion to essentially suppress this evidence because even if it's a modus operandi, that is how George Floyd acted when he was confronted by the police, it really isn't relevant. These are different police officers, and the police who deal with him, whether on May 6, 2019 or May 25th, 2020, have to deal with him as he presents himself. So whether it's part of a common scheme or plan or modus operandi or state of mind, it really doesn't matter. The intent that is relevant here is Mr. Chauvin, and he essentially has to deal with Mr. Floyd as is, without regard to, is it a common scheme or plan? Is it feigned, or, as Dr. Vinson would probably opine, it's anxiety or something else, a panic attack, genuine statements of claustrophobia. Whether it's any of those really doesn't matter, because the officers on scene have to deal with it as it is. So that was the original ruling and suppression of that. Since then, the parties have provided the court as a further offer proof evidence from a search of the squad car, Squad 320, which was the squad car that Mr. Floyd was placed in, or attempted to be placed in, on the date of his death, which was not searched until January of 2021. And am I correct that was the first search?
No, Your Honor, that was the second search. And the second search occurred only after the defense inspected Squad 320.
It's just kind of mind-boggling that an extensive search was not done until January 2021. Was the first one mostly just taking photographs?
Your Honor, the first search that was conducted, I believe, on May 26th or 27th, immediately following, the Squad 320 was searched. Numerous items of evidence were taken from that, including a ton of photographs. It was the defense review of those photographs that raised the question of what is all of this other stuff, why wasn't it taken? That's why we went to go look at it. But they did take DNA swabs. They took quite a bit of evidence from Squad 320 back in May of last year.
All right, thank you. Well, that puts it in perspective. But also, the body-worn cameras seem to include, I think, what is labeled as a narcotics body-worn camera. I'm not sure what officer it is. It's rather lengthy. It involves a lot of time where Mr. Floyd is in a conference room by himself, but also has a video of a paramedic dealing with him and checking his blood pressure. That was not part, or did I just miss it? Was that part of the September 11th motion hearing, or has that been supplied since then?
Your Honor, that was again when the parties were all joined, and the two of the other defendants made this motion, and Mr. Chauvin joined in that motion, and in the exhibits. I don't have a recollection as to whether that was included or not. I do know that it was specifically referenced in Mr. Tao's motion, and I believe that it was previously submitted as well.
Okay, and I think the motion was basically to talk about Mr. Floyd's manner and appearance during the arrest. And so the court made the ruling on that basis. Now we are at a different stage. Mr. Nelson, I'm going to ask you to approach the lectern and tell me why I should admit it and on what basis.
All right, so let's break that down before we talk about the defense attorney. So he's sort of framing out the court's original ruling, why they denied that. So again, the defense attorney's trying to get in that evidence of 2019 arrest of George Floyd. The judge is saying, well, it wasn't relevant. So we're not, I previously said that this is not coming in. We don't need to talk about it because it doesn't matter. It doesn't matter what happened in 2019. It only matters what happened in 2020 because Chauvin, Tao, any of the other officers who were there, they didn't know about what happened in 2019. So it wouldn't impact how they were dealing with him. They had to deal with him as he was right then and there. And so for the defense to come in and now say, well, yeah, but he was sort of acting in conformity with something that happened in 2019. He was following the same pattern. He says, well, so what? They still had to deal with him right then and there. If he had done that, if he had ultimately ingested a bunch of drugs, that doesn't impact Derek Chauvin's response and how he was supposed to deal with it. And so he's sort of, in my opinion, I think he's kind of making this more about the defendants and about whether Derek Chauvin intended to do what he did to kill George Floyd rather than identifying a different cause. So we're trying to sort of pin the tail on the donkey. Who is responsible for establishing this causal connection? What the defense is trying to do is say, well, this connection exists from this 2019 case because he ingested a bunch of drugs there. They're going to try to make that same argument. And that was the cause of the death. It was the ingestion of the drugs, not anything that Derek Chauvin had to do. It had nothing to do with the knee is going to be their argument. And the judge is saying, well, I'm not so sure about that. The Derek Chauvin had to deal with him regardless of that, whether he was on drugs or not. It's kind of his responsibility either way to conduct himself according to the law. And the real crux of the case is whether that conduct was a violation of the law. So the judge, he hasn't issued a ruling on this yet. He's going to probably address it tomorrow, but this is a big, big part of the case. And so I know when you listen to some of this back and forth, it's kind of fast and they're sort of leaving out some of the colorful stuff to put some meat on the bones. But this is very important. If this comes in, it's a game changer. Probably is not going to come in because it would be such a big game changer. And again, they're going to weigh the sort of the probative value versus the prejudicial effect, whether or not, if this comes in, if this evidence of this 2019 arrest comes in, is that going to take over the trial? Is that going to overweigh any of the allegations that we're discussing right now? Is it going to confuse the jury or prejudice the government? Judge is probably going to find that, yes, it does. Let's listen, though, to Eric Nelson and see what he has to say.
Thank you, Your Honor. We are advancing 4 bases. First, common plan or scheme, otherwise known as modus operandi, habit, intent, and absence of mistake. I think what the court is alluding to is in terms of the conversation with paramedics, at that particular point, when the paramedics were checking Mr. Floyd's blood pressure, they specifically told him that his blood pressure was so high that he was in danger of having a stroke or heart attack at that point. And obviously, in this particular case, one of the primary cause of death is obviously cardiopulmonary arrest. So just to kind of work backwards, Your Honor, and I think that that's what the court was ultimately alluding to. The entire arrest in May of 2019, just over a year prior to Mr. Floyd's death, is remarkably similar in multiple ways from one to the next, from the May 6th of 2019 to the May 25th of 2020 arrest. Beginning with literally the initial approach of officers and how the officers reacted to Mr. Floyd in that circumstance. In both of these cases, Mr. Floyd is in a vehicle, and one it's a traffic stop, and the other he's already parked. Officers approach, and the officers notice that Mr. Floyd begins acting furtively, hiding his hands. He's refusing to show his hands. Both officers, in both incidents, draw their weapons and escalate the use of authority or force in that regard. Mr. Floyd struggles. They struggle to get Mr. Floyd out of the car. Mr. Floyd immediately claims that he has previously been shot in both incidents. Mr. Floyd, again, struggles to get out of the car. He appears to resist their efforts to handcuff him. And he starts saying some of the exact same things that he says in this particular case, in the May 25th of 2020 incident, including calling out for his mama. He claims to have been shot, and he begins this crying, kind of erratic behavior. All of Mr. Floyd's behaviors at that point are identical. Now, in the May 6th of 2019 incident, officers actually observe Mr. Floyd begin to put what they suspect are controlled substances in his mouth. And they threaten to tase him. They say, spit it out repeatedly. Mr. Floyd refuses to comply. And he obviously takes these controlled substances. A search of the vehicle in the May 6th of 2019 incident reveals a large quantity of a variety of controlled substances. At the time of the original motion in this case, we had taken screenshots from the arrest in May of 2020 showing what we believed to be controlled substances in the mouth of Mr. Floyd at that time.
Well, in fact, I think I stated that in one of our hearings,
You
whether
did.
it was June or September, and the court, or the state at that time, before item 51 was found in the squad, I believe correctly and said we don't know that to be the case, that is a pill or spit or something else.
That's precisely it, Your Honor, and that was that. They said we don't know. That could have been could have been gum. It could have been something else. We didn't know with definite positivity. I don't think anybody could say with definite positivity at that point that that's what was in his mouth back at that motion here. Now there are so many other similarities between these two incidents, including officers believing that Mr. Floyd was under the influence in both cases. In the May of 2020 incident, officers King and Lane are asking him immediately upon taking him out of the car, "What are you on? What are you taking?" They suspect that he is under the influence of something. They don't know what. What are you taking? They notice a white foam around his mouth, or a white residue or something around his mouth. That same observation is also made by officers in the May 6th of 2019. So there are all of these remarkable similarities. The difference is, the primary difference is that in the May 6th of 2019 incident, when they put Mr. Floyd into the squad car, he never makes a claim of claustrophobia. He gets into the squad car and he continues kind of the crying and erratic behavior in the squad car. As his body ingests or processes the controlled substances he took, you can see his demeanor change in the cameras, where he goes to an almost incoherent state while he is in the police station in the May of 2019 state, resulting in the police calling paramedics to the scene, and ultimately the hospitalization of Mr. Floyd. And there are the associated medical records from HCMC, or what was then known as HCMC, about Mr. Floyd's hospitalization. Those records indicate that on that particular day he took 7 or 8 pills prior to being arrested by the police. The paramedics in that instance, right, when they originally respond to the precinct in May of 2019, they specifically tell him, they're monitoring his vitals, and they tell him, "You're at risk of having a heart attack or stroke." And his medical records also clearly demonstrate that he has a history of high blood pressure and hypertension. He had been prescribed medications for those. So you've got a person who is being specifically told this behavior, or presumably this behavior, is putting you at risk of having a heart attack or a stroke. So when we look at the exceptions to the general 404B exclusion, we look at common plan or scheme, right? Is this something that is so similar? Is this just that this is his modus operandi of when he gets arrested by the police? He, particular when he's in possession of controlled substances. So you look at this, and the similarities are incredible. I mean, it's the exact same behavior in 2 incidents, almost exactly 1 year apart. You also look.
All right, so we'll stop it right there. Yeah, very, very, very interesting there. Let me try to break it down just a little bit. I think he did a very nice job explaining about what he's trying to do. He's going back to the 2019 case. He's comparing it to the 2020 case, and he's saying, look, there are so many similarities here that we can presume safely that he probably was acting in conformity with the same behavior that we saw in 2019. And so let's think about this from a policy level. Why does the court not want that to come in? Why do they not want to hear about this at all? Because you may be watching this going, well, yeah, that's absolutely relevant. Are you kidding me? If he was arrested in 2019, ingested what he said 7, 8, 9, 10, 11 different pills, was hospitalized as a result of it, and was told that that he had other heart problems back then. We know from the current autopsy report that he already had heart problems, 2 different types that we covered, also had COVID and some additional things in there. But if you can show that in 2019 that's what he did, and Eric Nelson goes through it, and it says when he's in the back of the police car, and they had already told him to spit out the drugs, he consumed them. And then as his body is processing the drugs, he goes from his very excited, almost delirium state into somebody who is overdosing on drugs right in front of their eyes. Sort of as minute by minute it goes by, you can see his demeanor change in the back of the vehicle. That happened in 2019. And it kind of sounds like exactly what happened in 2020 is the defense argument. And he's saying, we want to be able to talk about that. And you say it might be obvious, right? But why would the court not want that to come in? Well, it's because if it does come in, you can feel kind of how damning that is. You can just feel that a juror, you might be sitting there watching this going, oh yeah, that changes the game. That changes everything. If we know that he did it before, we can presume he did it right now. And so that might be the whole trial, just based on that fact. And so the court doesn't want to do that. They don't want a trial based on some prior incident. They want it on these facts right here and now. And so they don't want to give either the prosecution or the defense. And remember, typically this is the government trying to get this evidence in. Typically it's George Floyd or somebody in his position would be the defendant in the case, and the prosecution wants to come in and bring in all of the priors and say, look, this guy stole a candy bar in 2018, 19, and 20, and so now it's 2021, and we think he stole a candy bar, but we don't really know. So we don't really have any evidence in this 2021 case, but we do have evidence about 18, 19, and 20, and so we're going to try to bring in all of those prior bad acts of the candy bar thefts from those prior years in order to prove the 2021 theft. And of course, no, that's not right? You can't do that because you can't presume that. And there's a very, very big risk there that maybe that time in 2021, he didn't actually steal the candy bar, but he's getting pinned with this one because of his prior bad acts. And so the courts get very concerned about this. They don't want to allow this stuff to happen. They know that it's bad. They know that it's dangerous. They know that if a jury heard this, it might be the case right there for him. And so the judge is really going to do what he can to keep this stuff out because it is so impactful. And so what Eric Nelson is doing is he's trying to argue some of the exceptions to the rule. And he goes through and he talks about habit and modus operandi. And there's some different exclusions that say, well, we know it's so dangerous that we really are by default not allowed to talk about this stuff. But in this limited case, because it is so important as to one specific issue, they ask the court to let it in. And so the judge is going to have to make a big decision on this. And it's going to be contentious. I'd say this is probably the first major contentious decision that we're going to get from the judge, whether to allow this or not. The other issues are important. Some of the jury questions I think have been pretty fair. Some of the motions in limine rulings have been fair. We have sort of fair guidelines across the board for expert witnesses and non-expert witnesses. And the judge, he's given us some guidance a little bit on whether he's going to sequester the jury or move the trial or continue the trial. And those are all sort of procedural issues. The settlement is a big issue, but that's not really within his wheelhouse. He's sort of having to deal with the damage and the spillage that's happening from the city council's incompetence. But now that he's going to work through those issues, this is the big decision for him. Does the prior come in or not? The government, of course, does not want it to come in. Typically, they want this stuff to come in because it makes the defendant look bad. But here, the tables are turned a little bit, so they really do not want it in. So this is, again, from the Star Tribune. It says, Judge Cahill questioned why the 2019 arrest is relevant, saying these are different police officers. Police have to deal with Floyd as he presents himself. Nelson countered, Floyd's behavior in the two incidents establishes a pattern. There are other similarities between these two incidents, including officers believing Floyd is on drugs. The similarities are incredible. It's the exact same behavior in two incidents, almost exactly 1 year apart. Prosecutor Matthew Frank came in here, and he called Nelson's motion to admit the 2019 arrest, quote, a desperation of the defense to disparage Floyd's struggles with opiate addiction. Frank accused the defense of trying to, quote, smear his reputation because he acted this way once before. Cahill said the May 2019 hypertensive incident goes to a possible cause of death in May 2020. In both incidents, Floyd had ingested drugs. That's the only relevance I see, adding that he would rule later on the issue. So again, this judge is going to have to give this some serious thought about whether to allow this in or not. I do not think that he allows it in. I just don't think he does because of its impact. Now, should he? That's a different question. We're going to have to see how these arguments flesh out. We're probably going to hear more arguments about this tomorrow. So we're going to switch gears a little bit. Of course, we're going to stay up to speed on this, but that's all taking place tomorrow. All right, so now let's talk about the jurors. So it looks like my emojis weren't fixed for some reason. One of them was fixed, so this one's good. But the old white woman is not showing up. This should be an old white woman with white hair. But that's our jury. This is what it looks like with demographics included with the emojis. So we've got 9 seated out of 14. No new additions to the jury panel right here. Mr. Blackwell, we saw yesterday. Sandeep. We saw the prosecutor, who is the assistant attorney general. He was doing a lot of the arguing today, a lot of the voir dire. And so, of course, the defense team has not changed either. We have no new jurors on the panel. Let's talk about the people who were booted out of here. We've got the first one. One jury candidate expressed concern that being a juror for several weeks during the school year would make it difficult for her to maintain in-class responsibilities as a teacher. The next prospective juror revealed that a work project he is on routinely exposes him to news headlines, including the one last week about the settlement, right? Everybody's going to see it. So 2 people were stricken there. We got 1 and 2 out. We've got then a woman was dismissed after explaining She's scheduled to move into a new home during the trial and has a child under 1 year old. All right, so she's out because we can't get her under sequestration. Cahill noted that 8 of the previous 11 possible jurors have been dismissed for various reasons rather than being seated or struck by the defense or the prosecution. So 8 out of 11 are they're just not. They just can't do it because the news and the media is so everywhere that they just can't escape it. They have also got some scheduling problems and things like that. I think some of the scheduling problems are, I don't know. I can't speculate, but you would think that a lot of that would have been figured out kind of before they get into the seat, but the judge is moving them on quickly as is. We've got some other people who got booted out. Extensive questioning by the defense of a 4th jury candidate on Tuesday yielded the same result, despite the man saying without qualification that he could judge the case fairly. Still, the defense used one of its peremptory strikes to dismiss the executive director of a youth organization who has the most interaction with police among potential jurors questioned so far, which is interesting. If he works a lot with the police, why would the defense strike him? Maybe he has some sympathies with the police that would make him a good juror. He said that in his childhood, he and his sister had to call the police when their parents would argue and physically fight. He added that he had no issue with how the officers responded in each instance. He also shared that he's a skateboarder. At times, you get yelled at by the police for cruising down the street. He called one time in Georgia when, as a youngster, when he and others were allowed in a skate park in the middle of the night. Police arrived, thought there was a break-in, and were pretty forceful verbally until the officers learned that the owner left a key for them. So he struck him. We don't see anything in this article about specifically, anything that I would see that would cause attention to that, but maybe it was just some of his appearance or how he was communicating his perspectives on the police. The defense also used the strike to excuse the morning's final jury candidate, a lover of the outdoors and fishermen, which you would think demographically tend to be more conservative people like police more than non-conservative people traditionally. These are broad strokes, but this is how it works. He said he could judge the evidence fairly and give Chauvin his constitutional right to a presumption of innocence, even though he thinks the defendant murdered Floyd. So there you go. That's why he got stricken with the peremptory. Said, I think it's very difficult based on what I've seen and what I've heard, but it's something I would definitely do, referring to his presumption of innocence. So he also got the strike. We have another one. The day's final jury candidate was questioned extensively about a long and close friendship with a police officer who works for large Twin Cities agencies, which is not the Minneapolis police. The man, a real estate agent, said he's gone on a couple of patrol ride-alongs. I did one of those in law school with his friend and saw, among other things, a citizen suffer a serious head injury, a drunken driving traffic stop, and someone who had died. All right, so this guy seems like he's got a lot of connection with law enforcement. So what is the prosecutor going to do? Let's take a look. Prosecutor Steve Schleicher posed many questions about the man's ability to weigh testimony from a law enforcement officer versus that of a bystander in light of the friendship and the ride-alongs. He said, quote, naturally, I would believe the police officer more, said the man, who lives in a suburb and has 3 grown children because they have more experience and training with what's going on than someone who is walking down the street. Cahill stepped in and zeroed in, so Cahill's the judge, and asked whether the law enforcement officer is more likely to tell the truth or a citizen. And he said, I guess more likely the police officer. The judge then excused the prospective juror, sparing the prosecution from using one of its remaining strikes. And, I didn't see this exchange, but that's very nice of the judge to do that and go in and strike that person for cause. I think that, if the guy said that he wanted to be fair and impartial, like some of the other people who've made it onto the panel, then maybe that could be salvaged. But again, I didn't watch it. So he got stricken by the court, stricken for cause. Probably the right thing, right? The guy said pretty clearly that he thinks that police officers are more likely to tell the truth. If you have 2 competing versions of events, then he's going to side with the police officer in front of a regular civilian. And this is so interesting to watch because typically we have to make those arguments. We have to go and convince people or communicate to people that, hey, just because he's a cop doesn't mean that everything he says is true. Just because he's wearing a uniform and a badge doesn't mean that he's as honest as, Mother Teresa or something. That's not the reality at all. Typically, we're trying to sort of explain to jurors that you don't have to believe the police. If he says the light was red and somebody else said the light was green, those are both equal. Those are both credible statements. And just because one is an officer doesn't mean that they've got more credibility than somebody else. Yes, they have more training, but it doesn't make their observation any less credible. just because of that, or any more credible because of that. And we have to sort of really flesh that out for people. Now it's the prosecutor who's having to sort of reverse that. The prosecutor is typically on the side of the police. Now he's having to go in there and find people who are a little bit questioning the police, whereas the defense is trying to find people who do in fact believe the police. And so it's sort of a reversal of the roles, which is always fun stuff. All right, so this is what the jury looks like. We've got, again, this is an old white woman, apparently not old. She's in her 50s. I shouldn't say that, right? But she's in her 50s. But it looks like this emoji. Okay, that's the emoji that I selected. So the emoji thing is turning into this whole racial just debacle. I'm not sure what kind of can of worms I've opened here, but that's how this stuff works. So we've got potential to, theoretically finish jury selection this week. Maybe we get 2 tomorrow. We've only ever seen a maximum of 2 added. So it would be 2 tomorrow, 2 on Thursday, and maybe 1 on Friday, or some combination thereof. So I think it still is possible to finish out the day, to finish out jury selection this week. Probably not going to happen though. We'll see. We've got a lot of other issues. This is the demographics board. So we can see no changes there from yesterday. So don't want to spend too much time on that, but just wanted to show that up for you. So let's take a look at some of the questions over from News Now Wyoming. These questions are being asked on watchingthewatchers.locals.com. You can support the show over there and ask some questions as well. So head on over there. First one comes in from News Now Wyoming. Do you have an opinion on how much of the prior act of George Floyd should come in? Watching the arguments this morning and hearing the judge's response, I can now understand why it may come in. Part 2 of my question, the judge said he can let in some, not all. So the medical expert saying, quote, this is the way George's body reacted to an overdose before, but leaving out anything about the arrest. So, it's a great question, News Now Wyoming, and I do have opinions on it, but I'm not going to share those right now. Number one, because I don't have all of the information out thus far. I would like to hear more about I'd like to see more of the evidence and specifically what they're talking about. The things that we have seen thus far are just sort of very surface level arguments. I personally think that it is relevant. And when we're having this conversation, we have to ask the question, why do we want that in? For what purpose? And you have to be very clear and articulate what purpose that is for. Is it to show that George Floyd took drugs? Well, we don't really know that, right? I mean, there's indications of it. We heard about the screenshot. It could have been gum in his mouth. It could have been spit. It could have been pills. It could have been drugs. We don't know. So is it to prove that, or is it to prove, or to at least cast doubt upon the ultimate cause of the death, which I think is really what it's intending to show. And so, I don't really have an opinion that I'm prepared to share right now. I certainly will critique the opinion that comes out. Part of the problem I have with sort of armchair quarterbacking this thing is that I haven't seen almost any of it. I've basically seen what you've seen. And so it's hard for me to give a very clear opinion on it. If the judge lets it in, I think that would be more appropriate to give context to this entire situation. But I understand if the judge doesn't. And if the judge splits it down the middle, that'll probably be fair. It's a good question, though. Sorry, I don't have a better answer there for you at News Now. It's a complicated issue, and so I kind of don't want to be too political with this issue, with this entire trial. I kind of want to just be more of an observer rather than somebody who's being a little bit more prescriptive about what I think should happen or take a side one way or the other. My big take here on this George Floyd stuff is I want a fair trial for both sides. Okay, I'm really not trying to get overly invested in one side or the other. I want to make sure that we're monitoring it and talking about it from the concept of fairness, impartiality, with due process, without any undue influence. And I'll be happy as long as we get something that looks close to that, because this whole thing is so messy that it can spiral out of control in a number of different ways. And I feel like the people who are politicizing this on both sides are doing a disservice to the justice system. And they're free to do that, right? They can have their opinions on it. But if somebody comes out and says, well, George Floyd was was murdered and Derek Chauvin was acquitted because of, white racism or the white patriarchy or something like that. Right? I want to be able to say, no, look, we covered it. We talked about it for almost an hour every single day of trial. We analyzed it, didn't see any of that stuff. And I want to be able to have some credibility when I make that claim. Or conversely, if everybody comes out and says, hey, Chauvin was convicted in the most unfair, most biased, most out of control kangaroo trial that we've ever seen, I want to be able to share my perspective on that without being too lumped in with one side or the other politically. And because truthfully, that's really what I believe in. That's kind of where that's my practice, the law firm here, right? We think that our clients deserve a fair trial. Doesn't even matter what they did. They deserve due process. They deserve their day in court. They deserve competent representation. And so Derek Chauvin deserves that as well. George Floyd and his family deserve justice also. So that's where my interest is, rather than making this overly political or trying to predict or sort of communicate where I think this is going or should go. We just want to analyze it. So, and I know that was a long little tangent, but thank you for indulging me. Ma Fox says, would the civil case be available for legal professionals via PACER with the estate of Floyd versus state case? We could figure out if the statement is accurate if transcripts, opinions are in writing. Yeah, good question. So, I don't know. I don't practice much, zero civil law, actually. So I don't know if those settlement agreements are on PACER, but I do have access to PACER, of course, so I will take a look and see if it is on there. Some of these settlement agreements oftentimes are just confidential, right? So they sort of will file a notice of settlement, but not the details of the contract. So they'll notify the court that there's a settlement that's been reached. It's kept under seal. It's all private between the parties. They're just notifying the court so that the court can then be aware and then be prepared for a dismissal of the litigation and take it off the docket. But that may be all that we see. But I will take a look at it. It's a good question. We should look at that. Ma Fox says, any sort of informal or formal opinion from the judge to two opposing counsels seeking RFCs would be on the record, correct? So what's an RFC, Ma? Throw that in the chat. I'm not sure what you're referencing there. We have, are they arguing whether to allow certain evidence? So yeah, so Ma, tell me what you're referencing from an RFC. And then I'll answer that. Jeremy Matrita says, are they arguing whether to allow certain evidence? Yeah, they are. And specifically, it is the 2019 Prior Bad Act. And that is George Floyd's prior arrest. They're also having conversations about Derek Chauvin and his prior disciplinary records. But the judge at this point in time has said those are not coming in. And Floyd's 2019 prior are not coming in. All right. So Ma says it's a request for comment. So any sort of formal or informal or formal opinion from the judge to two opposing counsel seeking requests for comment would be on the record, correct? I don't even know what you're referencing. So a request for comment on a motion or a settlement. I'm sorry, I'm totally blanking. I apologize. It's not you. I'm sure it's me. We have Nadar Lasir says, I'm not the brightest knife in the fridge, but even I know that releasing the settlement is irresponsible because it could potentially interfere with the idea of a free trial. If I know this, I'm willing to bet that a government official does too. So I don't believe their reason to do that was anything but maliciousness. Yeah, and it really does feel like that. I mean, they could have settled this before. They could have settled this after. They could have done like they have done historically. There's precedent for this, that in Minnesota, when they settled the Noor case, we heard about this yesterday, they announced the civil settlement the day of the verdict in parallel with the criminal case, resolved the civil case and the criminal case in parallel. City Council did that like a year ago. So they know that that is an option. I'm going to guess that a lot of the same people who are on the City Council for the Noor case are also on this same on the City Council for the current case. And for them to just go, oh, we didn't know. I mean, yes, golly, we're just trying to do our job as good city council people just to sort of rectify the situation with the Floyd family. We didn't know any better. Yeah, right. You all did. You knew what you were doing. And you did it intentionally at a time when it's very, very damaging to the case. Certain things happen when a jury selection starts. You kind of got to keep going once you start to impanel the jury. You can't really stop. If they would have done this, let's say, a week before jury selection started, the defense attorney could come in and say, well, we need a continuance on this. We need to change a venue. The court would have had more remedial options in order to address the potential for bias there. But now they just don't. They got to just, all right, well, we have like 7 jurors seated. We don't know if they're tainted. Now we have a bunch of other new people who are coming in. We got to ask them now, not only did they see the video, but did they also see the settlement? Because the city council just keeps dumping their garbage onto us. So the court is rightfully frustrated. I'm frustrated. It's like, what are they doing? It is not conducive to a fair and impartial trial. And the prosecuting attorney yesterday said something like, well, I don't know which way it cuts. Yeah, we all know which way it cuts. It's not good for the defendant. All right, next question. Here is Ryan. Says, how can a judge reasonably exclude evidence in a murder trial, in this case, ingestion of dangerous drugs, which can be medically contributing factors to the death, especially when ingestion immediately prior to the police confrontation would potentially point to a motive of framing the defendant via self-harm and suicide? Yeah, it's a good question, Ryan. A very, very, very astute comment here. And I think really what they're pointing out, or what the judge is trying to go to, is he's not necessarily talking about, well, so it depends on what we're talking about. If you're talking about the 2019 case, well, yeah, you can make an argument that that's not relevant. Okay, whether he ingested drugs in 2019 has no bearing on whether he ingested drugs on this day. If the defense thinks that happened, then they can present their evidence about what happened on this day. And the judge might go that route, right? He might just say, no, they got to prove it. If there was an ingestion of drugs, they can use the photograph. I think we've all seen the photograph where George Floyd is sort of sitting in his car with a shocked face, and you can see into his mouth, and he has something on his tongue. It's a pill, or it's a gum, or it's just, spittle that has accumulated there. We don't know. So the defense can make that argument. Now they want to be able to make that argument and reference the 2019 case and say, look, it happened back then, so this is what we think happened now. That's the crux of the argument. That's what they're trying to convince the judge of. And the judge might say, well, you can't do that because it's too damaging. It's too prejudicial. It's going to confuse the issues. It's going to make this trial about a 2019 case, which this is not about that. It's about a 2020 case. And so that's the argument. And so I think what we could be talking about 2 different cases and sort of confuse the issues. You got to make sure that we're keeping them very separate. If they're allowed to talk about 2019, it's for what purpose? And so they're going to have to flesh that out. But very, very great question, Ryan, and you've got a good handle on sort of the progression on how this is working. Paula MK says, if Chauvin is convicted, would the settlement be announced during voir dire be sole grounds for appeal? From a non-lawyer but true crime junkie, it seems that in order to get appeals heard and verdicts overturned nowadays, it takes a momentous act of God. Yeah, appeals are difficult to win. I mean, basically, you have to show some sort of abuse of discretion or some sort of issue that would have been fatal to the underlying case. It's a higher standard. Many people think that you can just lose a trial and just appeal for whatever reason. Well, I don't like the verdict. I don't like the outcome. No, that's not it. You have to show that procedurally that there was something that went wrong. Some evidence came into court that shouldn't have come into court. The judge made a decision about something that shouldn't have gone that way. I don't think that the fact that there was there was a settlement by itself is enough to say that this should be overturned on appeal, because it's definitely impactful. It's definitely, biased and prejudicial, but it is something that is external from the court. It's outside of the court. So the defendant, Derek Chauvin, would need to show the Court of Appeals or a higher court that something happened in the trial that was problematic. And one of those things could be that the judge dealt with the settlement inappropriately. The judge didn't grant a continuance, or didn't change venue, or didn't give him more peremptory strikes, or didn't strike certain jurors for cause after they've acknowledged that they've heard about the settlement agreement, or didn't sequester the jury. Any of those things would be appealable issues, which is why we're hearing Eric Nelson go down the list and just stake those all into the ground and see if something happens, if Derek Chauvin is convicted on the basis of one of those erroneous decisions, then that would be appealable. And then if that would potentially change the outcome of the trial, or the court could remand it for a new trial, there's a lot of different ways this can go. And it's too early to tell and dial in on the specifics. All right, Ma Fox in the house says, I'd like to know how long it took before the drugs took effect in his system in the 2019 case. I feel that'd be relevant. Effect in less than 15 minutes from a pill form is highly suspect in my opinion. Yeah, it's a good question, Ma. And I think there was some indication, not from the clip that we heard today, but from a clip that we played previously. It may have been last week, also from Eric Nelson, also talking about this issue. And he said that there was something in one of the reports somewhere where it sounded like George Floyd was actually chewing the drugs and just so that he could digest them very quickly. So because if I'm remembering correctly, there was some indication that from the report that there was saliva and residue from chewed up drugs. So sort of the pill form crushed up as he's fighting with the cops. It's sort of coming out of his mouth and it's smeared around the back of the police car. That's what they found. So if he is chewing it up and it's going directly into his bloodstream through his mouth, that might affect the timing. I don't know if it makes it, I think it makes it significantly shorter because it's going directly into your blood, not going through your digestive tract. But you'd also have to sync that up with the timing in the case. When did he start to, become under the influence of the drugs? We have Ma Fox says, any sort of informal or formal opinion from the judge to two opposing counsel seeking RFCs would be on the record from the judge on a settlement issue. Okay, so I think we're talking about, so a settlement issue. So the closest thing that I can analogize to here, Ma, is a settlement conference that takes place in a criminal case, okay? Because I don't do civil law, so I don't know what an RFC is, if that's a real thing, or if that's a thing in civil law. I'm sure it's a real thing, but I'm not familiar with it. So when we have settlement conferences in criminal law, those are informal proceedings. They're technically recorded, but they're also off the record. And so they're sort of in this little bit of a gray zone where you can say what you want on the record. You can be open and exchange information, exchange ideas. Well, what happens if we do this? Then the prosecutor can tell us that. What happens if I take this plea? We can explain what the penalties would be. What happens if I go to trial? We can talk about what the penalties might be. And so you can just kind of hash out a lot of issues back and forth in the conversation of settlement. And the benefit of that is you want both parties to be able to come out there and just communicate openly, candidly. You don't want people to be hiding behind fear that if you say something that's stupid or you incriminate yourself, that is going to be used against you. So you could say to the prosecutor, if I did that thing, or if I gave you information about this other thing, might we be able to negotiate it, and it might incriminate that person, but it's all sort of off the record. It's all informal, so you can have legitimate conversations. And a lot of those are just not available. Those are protected. Those are confidential. People don't want you to see that because it is sort of a sacred communication, free, off the record conversation. And so I'm going to guess that there's a similar version of that for George Floyd and his settlement with the family, that there are conversations that are public and that the judge will happily keep a part of the record. And then there are other areas of settlement negotiations that are just not on the record. Those are secret and you wouldn't be able to get access to any of that stuff. I would think that that would be similar, but I am actually going to look up that case on Pacer as soon as we're done here on the show, matter of fact. And I'll see you on Clubhouse, so we'll dive into that one as well. Paula MK says, also, do you know if the medics that were on the scene during Floyd's arrest are going to be witnesses? Almost certainly. I don't know for a fact, though. When the video first came out, I and my other shift medics didn't understand why the medics on scene weren't following normal protocol for cardiac arrest. Yeah, good question there, Paula. Very good question. I would be curious as to what your speculation on that might be, whether you think it was because they did something negligent there, or because they didn't identify this as a cardiac arrest, or what. I don't know. But yeah, almost certainly they're going to be there. I think most of the witnesses who were there, the people who recorded the videos, there are hundreds of witnesses on the list. We just don't know who's ultimately going to get called. Liberty or Death says, I was watching and saw the judge strike the last guy. His answers were subtle but slanted. I thought the judge was nice in excusing him, but for the same reason he did not grant Nelson's motion for another preemptive challenge, he should have left it for the prosecutor to use one of his strikes. Yeah, so you did watch that. Yeah, so I didn't watch that part of it live. I just was sort of clipping from the article. But yeah, the defense, did they get that same courtesy from the judge? The judge kind of stepping in and excusing people so that they don't have to use their peremptories. Now, the defense has more peremptories than the prosecution, but still, if you're going to be striking people who are kind of slanted for cause for the prosecution, you got to do that for the defense. And I didn't watch that one, so I didn't want to beat up on the judge too much a little bit, but it sounds like liberty or death. You were picking up what I'm putting down. We got Jack Elias says, wouldn't the city lose the civil suit since their training standard instructed the hold pin used by the officers and neglected to instruct them not to affect the hold pin for X minutes, nor any other restriction of its use? Wouldn't the city lose the civil suit since they instructed and neglected to instruct them not to affect that hold for X minutes, nor any other restriction of its use? So good question, Jack Elias. I would say that is for a civil lawyer and the civil different standards. It's irrelevant right now because there is not going to be a civil lawsuit. They settled it. Maybe their attorney came to the same conclusion and said, no, we're not going to risk this at trial. If we take this case to trial, we could lose. The settlement could be for $127 million for all we know. So we're just going to settle it for a steal at a cool $27 million. And that's that. They're not going to have to move forward. They may have made that calculation, or maybe not. Maybe they just said, yeah, we could win at trial, but we're going to make a political decision here. We're going to say that this is in the interest of settling down the city, calming down the city, calming the nerves for whatever reason. Maybe they think Chauvin's going to get acquitted. Maybe they think he's going to be convicted and it's still the right thing to do. Who knows? But it'll be curious to see if as this continues on, new comments or new story or emails or something leaks about the deliberations that were taking place in order to effectuate this settlement agreement. So that is it for the Derek Chauvin trial. We're going to be back tomorrow. We're going to see if we get any new jurors. We're going to see if we have any answers on the 2019 prior, whether that's going to be admissible or not. And so we hope you join us, same place, same time, for that conversation. All right, so we're going to change gears a little bit. Typically on this channel, we spend a lot of time talking about U.S. news. But today, we're talking about the U.K. We're talking about England. Sarah Everard was a woman, unfortunately, who's no longer with us. And there's a very interesting story that is percolating over in England that involves this young lady who was kidnapped and killed by a police officer who works in London. And so they have a lot of the same problems that we do here in the United States, unfortunately. Let's take a look and dive in. We're going to go through a little bit of background on Sarah Everard. She was 33 years old, beautiful young lady, and she's no longer with us. And this is something that could be very explosive for the police department. And so we're going to go through, learn about the timeline, learn about who she is. We're going to tell you about the investigation that's taking place in Europe. I'm not licensed to practice law in Europe, but we are going to go through it sort of as we would develop a regular criminal case here in the United States. Just keep that in mind that I do not practice law in the UK, and so things are naturally going to be different. All right, so let's take a look at Sarah Everard. This is who she is. A couple very nice pictures here from her. She was 33 years old, originally from York before moving to London 12 years ago. Marketing manager, last seen on Wednesday, March 3rd, so about 2 weeks ago. Sarah moved to the capital for work about 12 years ago, has a brother and sister who also live in London, so they are without their sister. A couple pictures here, won a nice medal at a marathon or something like that. Find Sarah. So CCTV, let me make sure, CCTV from near 33-year-old's home shows no sign of her returning to her flat where she lives on the night that she vanished. So here's the CCTV camera that you see here. So apparently they monitored it. Normally she would walk down this way and she didn't go home. She goes missing after leaving a friend's house in Clapham, South London, about 9 p.m. Sarah should have returned home near Brixton about 50 minutes later with police unclear on whether she made it back. CCTV footage from a local estate agent shows no one matching Sarah's description between 9:30 and 10:30 on the route police believe she would have taken home. So she was at a friend's, says, I'm leaving. They sort of recreate the timeline. She should have passed through here between 9:30 and 10:30, and she didn't. Camera has a clear view of both sides of the busy road on Brixton Hill, which is a closed flat which is close to the flat where the marketing manager lives alone. And so this was on Wednesday, March 3rd. Okay, so she goes to a friend's house and she is not returning home on March 3rd. We can see the date here at about 8:15. So they're looking from 9:30 to 10:30. They don't find her. Then we fast forward, March 6th. So 3 days go by. Metro Police issues an appeal over her disappearance and they release a CCTV image of her. Police said she was thought to have walked through Clapham Common after leaving her friend's flat and heading towards her home. The journey should have taken around 50 minutes. So they're they're reconstructing the timeline. Let's go through this. We have Sarah left her friend's house 9 p.m. on March 3rd. Sarah Brixton's home is a 50-minute walk from her start point. She is thought to have crossed through Clapham Common and was last seen on CCTV around Poinders Road around 9:30 p.m. A week later, officers searched a woodland near Ashford in relation to her case, as well as a property in Deal on the southeast coast. So they're searching around for her. So theoretically, you would say she would have walked, right through this commons and walked home. It's a 50-minute walk from her starting point. And it's late at night. And we have to look up these dates. What was March 3rd? Was that a weekend? Was she drinking? Was she out, having a party with her friends? Was walking home because she didn't want to drive home? I don't know how things are in this area in England, whether that is a common thing or maybe not. Maybe she was just there, having some fun. None of that was going on. Doesn't really matter either way, but it is interesting. Sunday, March 7th, so the next day, police released footage taken from a private doorbell type camera showing that Miss Everard walking alone at A205 Poinders Road toward Tulse Hill, south of Brixton. It's unclear if she reached home. She was last seen wearing a green rain jacket, navy blue trousers, white diamond pattern, turquoise and orange trainers, and was thought to have been wearing green earphones and a white beanie hat. So this is her last sighting of Sarah on CCTV around 9:30 p.m. The investigation into her appearance is being led by Scotland Yard's Specialist Crime Command because of the complex nature of the probe, which combines searches with house-to-house inquiries. So just a major, major search. So a couple of days, that's on Sunday the 7th. Then on March the 8th, we have more. Detective Chief Inspector Catherine Goodwin, who is leading the investigation, said, "This is definitely a missing person investigation at the moment, but I remain open-minded to all possibilities. 750 people have now been spoken to find her. They've trawled through hours of CCTV camera. DCI Goodwin has appeared for anyone with footage to come forward, especially anyone driving along the road. The evidence that you have on your dash cam could be absolutely vital to finding Sarah. Specialist officers have been drafted in from across the Metro Police. We all are looking to try to find Sarah as quickly as possible. It's understood detectives investigating her disappearance have been told of assaults on women in the area. January, Metro PD received report of sexual harassment. At the start of February, a woman was witnessed being chased by a man just over a mile away. Just 3 weeks ago, 14-year-old girl, similar situation. Meanwhile, other women reported groups of men following a woman in neighboring district in Balham. Scotland Yard said, so far, it's not linking the disappearance to any of the other incidents. It comes after alarmed women living in the area revealed police urged them to be vigilant after the mysterious disappearance. One said cops knocked on her door last night and warned her not to go out alone as they desperately try to piece together what happened. So they're actually knocking on people's doors over there. Tuesday, March 9th, 1 week ago, sniffer dogs search gardens in streets and near a search site near Miss Everard's Invisage route home near the Oaklands estate. They search a pond, so they're looking for her. Fresh images are also released of her wearing a coat in which she disappeared. Later that day, Met sets up a cordon, and Met sounds, I think, Met is the name for the police. So it's like the Metro Police, they call them Met instead of Metro. Housing complex on Poinders Road is part of the search with forensics officers seen examining the area. Missing posters goes up. Please help. Our dear friend, Sarah Everard. Last contact, 2128, Wednesday, March 3rd. Wearing this green waterproof jacket, 33 years old. Missing posters have been issued. She had this phone, these shoes, these pants you can see here. And its story goes on. Midnight, March 9th, Met police officer arrested in Kent over the Sarah Everard disappearance. What on earth? A police officer is arrested for it? What? Police officer has been arrested in connection with the disappearance. Officers arrested him at the address in Kent last night, March 9th. He has been taken into custody at London Police Station where he remains. A woman has also been arrested at the same location on suspicion of assisting an offender. She has also been taken into custody at a London Police Station. Assistant Commissioner Nick Epgrave says the arrest of this evening is a very serious and significant development. We will continue to work with all speed on this investigation, but the fact that the arrested man is a serving Metro police officer is both shocking and deeply disturbing. Yeah. I understand there will be significant public concern, but it is essential that the investigative team are given time and space to continue their work, which typically is code word for we're not going to tell you anything about the guy, not going to reveal much information about him if we can help it. Wednesday, March 10th. The Mets, the police, revealed the officer arrested on Tuesday was not on active duty at the time of her appearance, but Com Epgrave initially refused to provide details of the offense on which the officer has been arrested on suspicion of, or how long he has served on the force. Of course. We all knew that was coming. Detectives began searching 2 locations in Kent, including a property in Deal and Woodland near Ashford. A tent was erected outside a house, car being seen taken away from the property. ITV News told a police officer lives at the address with his wife and 2 children, said they just seemed like a normal, regular family. There was nothing strange about them at all. Miss Everard's uncle, Nick, talks to the media to say that the family are distraught. Things are utterly dire, waiting for positive news from the police. So he's arrested. We have not identified where she is or what happened yet. Afternoon on Wednesday, March 10th, Scotland Yard confirms that the police officer has been arrested on suspicion of murder. So this is the guy, very bad police officer that we, as far as we can tell, currently, is being alleged to have committed this crime, but it seemed like they are pretty clear about it. He is later identified as Wayne Cousins, 48-year-old, serving in the force's Parliamentary and Diplomatic Protection Command. Wow, that's a name right there. Parliamentary and Diplomatic Protection Command. He was held on Tuesday evening on suspicion of kidnapping before being further arrested on suspicion of murder and a separate allegation of indecent exposure. The PO arrested in the Sarah Everard case, Wayne Cousins, age 48, married and living in Deal, was a car mechanic until 10 years ago, based at Westminster, and would know the SC well, OBS. It's been suggested by a source that he may have been lodged at a CP estate. So yeah, it looks like the same guy there. Human remains, though, were found on Wednesday evening in Kentwood. Human remains have been found in the search for Sarah Everard, made in an area of Woodland, Ashford, and Kent. We're not able to confirm any identity. That may take some considerable time, which means that the remains are beyond recognition. So somebody was trying to, of course, cover up the crime by eliminating the body, which is not good. Morning, Tuesday, March 11th. Police are continuing to question the officer arrested. Afternoon, March 11th. Metro PD reveals he has been taken to a hospital. Suspected of kidnapping and murdering. He has been taken to a hospital for a head wound sustained while in custody. What? Scotland Yard said the suspect was treated, discharged, and returned to the police station. Miss Everard's family said she was kind, thoughtful, caring, and dependable. They appealed for information about the 33-year-old's disappearance. The police watchdog announced it launched an investigation into whether Metro police officers, quote, responded appropriately to a report of indecent exposure following referrals linked to the arrest. Independent Office for Police Conduct, IOPC, said its independent probe follows conduct referral from the force, linked to 4 other referrals. Then the afternoon, Friday, March 10th, so this was last week, police confirmed the missing woman's body is found. Sarah Everard was identified late last week. Earlier, speaking outside Scotland Yard, Assistant Commissioner Nick Epgrave gave a televised update on the police inquiry. As you know, Wednesday evening, detectives investigating the disappearance of Sarah Everard discovered a body. Here he is explaining the story.
As you know, on Wednesday evening, detectives investigating the disappearance of Sarah Everard discovered a body secreted in Woodland in Kent. The body has now been recovered and a formal identification procedure has been undertaken. I can now confirm that it is the body of Sarah Everard. Clearly, Sarah's family have been updated with this most distressing news, and I just want to pause for a moment and say that my thoughts and prayers and those of the entire organisation remain with her and with them at this awful time. Specialist officers remain in constant contact with Sarah's family and will continue to support them throughout the investigation and beyond. That investigation continues at a pace, and we have hundreds of officers working round the clock to establish the full circumstances of Sarah's disappearance and her murder. And the man remains in custody at a London police station on suspicion of committing those crimes. I know that the public feel hurt and angry about what has happened. And those are sentiments that I share personally, and I know my colleagues here at Scotland Yard and across the Met share as well. I also recognise the wider concerns that are being raised quite rightly about the safety of women in public spaces in London and also elsewhere in the country. I want to say now that this organisation and the men and women in it remain committed to protecting Londoners wherever they are in this city. And that commitment is undiminished by these events, and if anything, that commitment is strengthened by these tragic circumstances. Thank you very much.
All right. So, a nice statement, pretty, standard stuff there. Obviously awful, just awful. I understand the need to stop and mourn for people who we have lost. I understand the need for an investigation, but I've been very critical about this a lot on this channel, that I think the police owe it to open up their investigation so that the public can see what is happening, in particular when it happens with one of their own. I understand the need in certain cases that when it doesn't involve their own people to want to keep stuff kind of hush-hush and not confirm or deny and all that stuff. I get that there are some good policy reasons for that. But when it's one of your own people, it demands a higher level of transparency, a higher level of accountability. We want to know what's going on with this guy. What's going on with the other officers? Was there anybody else who's compromising in this thing? Was he acting alone? Was somebody else covering up for him? Why did it take a week? What was going on with the investigation? Because this is somebody who is, until a week ago, was somebody that the English people presumably thought to be a credible, competent, safety-oriented public servant, police officer. And he's not. So it kind of shakes the foundation of the police department, of the police agencies. And so I think as a public, we should be demanding that they communicate to us about the extent, what's going on with the investigation, what's happening there, rather than just keeping this stuff all under seal as they always do. So this is some more background on the story. Evening of March 12th, he's charged with kidnapping and murder. Police said the guy was taken to the hospital, 48 hours for treatment, discharged and returned back to the police. A lot of this looks like it's the same information. Here, Cousins has been remanded to custody at the Old Bailey on the 16th of March. The defendant, wearing a gray, he's supposed to appear today, 16th of March. He's wearing a gray tracksuit, appeared to have a wound on the top of his forehead, stood as the charges were put to him. He spoke only to confirm his name and personal details, sitting between two plainclothes officers in the dock. The court heard that Cousins is accused of kidnapping Everard in the area of Chatham. The chief magistrate, Paul Goldspring, said, quote, "I don't have the power to consider the question of bail. That will be considered should you wish to make an application to the court on March 16th. You are therefore remanded into custody until that date. Both charges have been sent to the Crown Court." The Met previously said Cousins joined the force in 2018, most recently served in an armed unit responsible for guarding the parliamentary estate and embassies in London. His main job was uniform patrol of diplomatic buildings, and Scotland Yard said he was not on duty at the time of the disappearance. He had been previously working at a garage run by his family. Force said Cousins was taken to a hospital for a second time in 48 hours for treatment of the head injury. He was treated in the hospital for a separate head wound, which the Met said was sustained when he was alone in his cell. So is he trying to injure himself? Is he trying to kill himself? It sounds like he's in there beating his head against the wall, and he's doing it again. So hopefully that is being dealt with. Next up, we've got Sarah Everard, a trial set for murder, accused the PC Wayne Cousins. So the judge set a hearing date for July 9th and a provisional trial date for 25th of October. So this is obviously going to be something I think is going to be in the forefront of a lot of people over there in England. The court heard the provisional trial could last up to 4 weeks. Prosecutor Tom Little, QC, said the circumstances of the case had led to a, quote, very significant and wide-ranging investigation, and more of that will be revealed, I'm sure. He told the court that the case had attracted almost unprecedented media and public attention. No bail application was made by defense barrister James Sturman, who also said legal aid was yet to be granted. So the public response to this, as he is noting, is massive there in London. Let's take a look at what's going on over there, because as we know, when people get mad at law enforcement, they have things to say about that. So let's take a look at this story, which came over from the New York Times. Banned vigil for Sarah Everard becomes a large anti-violence rally instead. What? Why would they ban a vigil over there? Thousands of people gathered in South London on Saturday for a vigil in tribute to Sarah Everard, 33-year-old marketing executive whose killing has touched off a national reckoning over violence against women despite police warnings the event would be unlawful. So the police are warning that if you protest the death of somebody that one of the police killed, That's unlawful. All right. As darkness fell, crowd growed chanting, "Shame on you," and how many more? In what became a rally against gender violence, some clapped their hands and others held tea lights and signs that read, "End violence against women," and she was only walking home. More than 30 gatherings were planned across Britain on Saturday, and what organizers hoped would convey the outpouring of solidarity and anger that Miss Everard's killing had set off this week. Thousands of women shared their stories across social media, now symbolizing an issue that many say plagues Britain. And the story goes on. Lawmakers and activists and civil rights organizations, women's rights organizations, they gathered around. Organizers, 9 women from the Umbrella Group, said the police told them that they would face fines of £10,000 or $14,000 if they went ahead with their plans. James Klingler, one of the planners, said the organizers had suggested an alternative venue. We're protesting violence against women. Are you at the rally on Saturday evening? Several protesters shouted, "Who do you protect?" at police forces. Officers forcefully removed protesters standing under a pavilion in the park, which had been turned into a memorial for Miss Everard. The Metro Police Force has been under criticism for days. On Thursday, Police Watchdog said it was investigating whether 2 officers had responded appropriately to an allegation of indecent exposure against Mr. Couzens. The officer who was charged with killing Miss Everard is suspected of having exposed himself at a fast food restaurant in South London days before Miss Everard went missing. So there it is. What happens if they just threw that out, whether they responded appropriately to an indecent exposure allegation against Mr. Couzens? So somebody already made a claim against this guy. Why wasn't he suspended? It remains unclear why he wasn't suspended. Yeah, it's a good question. The scale of the gathering on Saturday, along with the outpouring of accounts of harassment, is likely to add pressure on Boris Johnson's government, which is scheduled to unveil a plan to tackle violence against women. Lawmakers are set to debate a bill, and they're going to suggest several lawmakers have supported vigils going forward despite the restrictions. And so we've got some imagery of it. And here is one. It looks like maybe people out there with cell phones or lighters, maybe their cell phones, flashlights in support. Here is another one. A lot of people out there. Your pain is our pain. A lot of flowers. Major outpouring of love for Sarah, which is very good to see. People are kind of tired of this stuff all around the country. All around the country in England, all around the country here, people are sick of it. Scuffles break out at Clapham Common Memorial for Sarah Everard as people chant arrest your own. Yeah, police. All right, so we'll leave that out of there. YouTube doesn't like those videos, but it's not just here in the States. People are tired of cops killing people throughout the world. So England's dealing with it as well. And Sadiq Khan, the mayor of London, released a full statement. It's my full statement following meeting with the Met Commissioner to discuss the policing of the vigil on the Clapham Common last night. The scenes arising from the policing of the vigil for Sarah were completely unacceptable. My thoughts remain with Sarah's family at this time. I can completely understand why women, girls, and allies wanted to hold a vigil to remember Sarah and all women who've been subjected to violence. Last week, I called on the government to work with organizers. On Friday, a high court judge made clear there was a window to agree a way for a vigil to go ahead safely. I received assurances from the Metropolitan Police last week that the vigil would be policed sensitively. In my view, this was not the case. No, we just watched the video of it. I asked the commissioner and deputy commissioner to come into City Hall today to give me an explanation of yesterday's events and the days leading up to them. I am not satisfied with the explanation they have provided. I will now be asking Her Majesty's Inspectorate of the Constabulary, totally different words over there. It's just great, to conduct a full independent investigation of events yesterday and in previous days. I'm also asking the Independent Office for Police Conduct to investigate the actions of the police officers yesterday evening. It is vital that these events are not allowed to undermine the powerful calls since the murder to finally stop men from inflicting women. Criminal justice system more widely, further steps must be taken to address this. So, interesting case. You know, I have a lot of issues with, of course, the underlying story, but I have a bigger issue in many situations with the police not being transparent about what they're communicating about what's happening here. So you have the police do something wrong, and I understand that. Police do something wrong. Lawyers do something wrong. Everybody does something wrong. We're all human beings. But the bigger issue is the cover-up, or it's the lack of accountability, the lack of transparency. It's what you saw. People want to show up and show their support, and the next thing they know, they're getting threatened with $14,000 fines, and it turns into mayhem. And it's the police. And this is hot water because it's the police responding to one of their own who broke the law. And there's going to be a lot of questions about whether they properly investigated that guy for his indecent exposure allegation, whether there was any hint that it was him early on in the investigation. Did that get delayed a little bit? How did this whole thing come to be? How did they find him? Maybe we'll know more about that. Going to keep a look on this story. We have a warning over here from News Now Wyoming says, careful with reporting on UK issues. Their defamation laws are whack. Very easy to fall prey. Well, maybe they're going to sue me for defamation for saying that their defamation laws are whack. Can't escape it. I'll be careful with that, right? I don't want to defame anybody in America or anywhere in the world. Just want to cover the news, do some analysis, hopefully move the needle forward in helping myself and other people understand what is really going on. J-Bone, 86, J-Bone in the house says, did you see where a Green MP wants to ban men from being out after 6:30 p.m. as a result of the Everard murder? Only problem is they could identify as women. Isn't that how it works? Yes. No, I did not see that. But yes, there's always a response, right? There's always somebody who wants to do something about everything. Banning men from leaving at 6:30 p.m., not sure that is the right answer to deal with law enforcement. One of their own was responsible for that. Why should all of society's men be under curfew? Sasha Shisha in the house. Haven't seen Sasha in a while. Says, took a month-ish break from politics. Hey, you're back. Yeah, it's a good one. A month break would probably be a good, nice, refreshing thing. He says, all refreshed and only to find out you have been demonetized. I know. Can you believe it? Finally caught up with your videos during the weekend. Glad to be here and glad to be supporting R&R as usual. Keep up the good work. Well, Sasha Shisha, so good to have you back. I hope you are rested. A month off of politics. I don't know if I could do that, quite frankly, but it does sound nice. We're happy that you're back and with us. Thank you for that very, very nice message. We have another one from NY Renal MD. The last one in this segment says, it's time in the USA to have a discussion on removing qualified immunity and its source, sovereign immunity. People are tired of hearing how the police get the benefit of the doubt in every sense. Yeah, I couldn't agree more with that. I mean, qualified immunity is sort of this made up doctrine anyway. It's kind of just been written into the rules. And I think it's time to revisit that and decide whether that is something that we still want in place. Because in my opinion, I think it creates some pretty perverse incentives for law enforcement to do certain things, knowing that they're going to be immune from any prosecution or any civil liability, and they're going to be able to escape without any ounce of culpability. So I would be open to that. And it sounds like we're not alone here in the USA. I'm sure they have something similar in the UK and elsewhere around the world, and people are just sick of it. You know, the default with the police is that everything's okay and everything's right and everything's by the book and everything's transparent. And you have these very nice officers who I'm sure are good people who come out and they put on the face and they do these little statements in front of everybody and we're sorry, we're so sorry, and for the family and all of this. And okay, we get it, but we want to know now. We appreciate that. We appreciate all the thoughts and prayers. We appreciate all the I know you're commiserating with us. We got it. But what are you doing? What was going on with this investigation? What are your internal policies and procedures? And I don't know if I'm being overly harsh on the police in the UK. I'm just sort of extrapolating that they have the same problems that we do based on this story. And I'm sort of stereotyping how they structure their enforcement organizations over there, but largely because the U.S. is based on a lot of English law and old common law. Going to guess that we kind of have the same ancestor, so a lot of our justice systems have developed more or less kind of hand in hand, and that you are experiencing the same problems and frustrations that we are here in the United States. All right, so the last segment of the day, we're going to get back into politics. We're going to talk about H.R. 1. H.R. 1 for the People Act is something we've talked about here. We went through the bill, kind of laughed at it about all the ridiculousness that is inside. I have been sort of shocked to see that this is even a real bill, because I think it is so in violation of many different sections of our Constitution that it's really just kind of a joke. But it's not a joke anymore. They're trying to move this thing forward. We know the last time that we talked about it, it had already passed the House of Representatives. And so this is from the congressional website. You can see this is H.R. 1 for the People Act, passed of 2021, sponsored by Rep. Sarbanes. And we can see here that it did pass the House. And so now it's going on over to the Senate. And on March 11th, it was received in the Senate. Here's a little list of what's been going on it. A lot of activity early on in the month, still in the House of Representatives, but then it got transferred over to the Senate. And we'll note that it was received in the Senate. And the reason why I sort of was kind of laughing at this the last time that we talked about it, maybe a week ago or 2 weeks ago, was because I was thinking there is no way that this is ever going to pass in the Senate. Remember, we have the filibuster, and the Democrats only have 50 seats in the Senate. And we already know that certain people, certain senators have sort of expressed opposition to eliminating the filibuster. And I'm going to explain what the filibuster here is in a minute. But now the long and short of this whole segment is that they're trying to essentially rewrite the Senate rules so that they can get around the filibuster. And so my protection, my thought that this will never pass in the Senate, is not so, it's not on solid ground anymore. If the filibuster is not in existence, or if Mitch McConnell has made his statement on it, but if Chuck Schumer and some of the other Democratic leaders in the Senate want to rewrite the rules so that they can pass through voting bills and do an end run around the filibuster, then there is no protection. There is no last line of defense against H.R. 1 becoming law. And they're working hard at this. And so I want to break this down. We're going to first talk about what a filibuster is. We hear this a lot, but let's understand what it means, because I think it is important. Then I'm going to show you what Stacey Abrams, who is a big voting rights person, she's somebody who I think was critical in helping the Democrats win those 2 seats in Georgia for Ossoff and Warnock. For those 2 guys, I believe were the two senators. I might have been missing their names up, but she was instrumental in getting them elected in Georgia. She was instrumental in a lot of the elections throughout this country, and she has been sort of the spokesperson for getting this through. So I'm going to show you what the filibuster is. This comes over from the United States Senate. You can find this. This is their explanation of this. So what is a filibuster? And you may have heard about these filibusters where they'll get up there in Congress and they'll just talk for 12 hours. Rand Paul did it at one point in time. I forget what he was talking about. And then Ted Cruz did it at another point in time. And they talk for 12 hours, 16 hours, or whatever it is. And that's kind of the standing, talking filibuster, which is what many people think when they hear the word filibuster. But it's also just a procedural concept. And so let's break down what this means. The Senate tradition of unlimited debate, meaning they start with unlimited debate. It has allowed for the use of the filibuster, which is a loosely defined term for action that is designed to prolong the debate and delay or prevent a vote on a bill, resolution, amendment, or other debatable question. So you can kind of spend a lot of time unpacking that, but the theory is the Senate wants debate. That's where they have debates. And so that has been a tradition there that, well, we're going to allow debate to go on. The only way to end that is by, well, didn't happen until 1917. This was a long-standing tradition. Prior to 1917, the Senate rules did not provide a way to end debate and force a vote on a measure. So that means if you don't have cloture, which is something that they adopted recently, then you can just debate and debate and debate and debate. And you can just add on amendments and you can just submit modifications and change the bills. And basically, because there's no closure on the bill, you can just extend this indefinitely and bills will die during the debate phase. However, in 1917, they did adopt rules. That year in 1917, the Senate adopted a rule to allow a 2/3 majority to end the filibuster. This is a procedure known as cloture, which kind of sounds like closing the debate. If 2/3 of the Senate says, "Now we're done debating this issue, we can close it, and then we can go and move for formal votes and formal momentum on the bill." In 1975, the Senate reduced the number of votes required from cloture from 2/3, which is 67 of the 100, down to 3/5, which is 60 of the 100. And so right now, that's the current rule. If they want to pass H.R. 1, they're going to have to overcome the filibuster because they're not going to get 10 Republicans who are going to join and cross the aisle with the Democrats and vote for cloture, which would close the debate window and allow H.R. 1 to come forward for a formal vote. And so what are they going to do about that? Well, they can't get this through. What's the prospective? What's the option? Well, Stacey Abrams says we need an exemption to that rule. We're going to get around that a little bit. Here she is on Meet the Press over the weekend.
I want to start with the issue of H.R. 1. The House has passed this bill. The reality is it's not going to overcome the Senate filibuster. So I guess my question for you is, do you think it's that Democrats should pare down H.R. 1, focus it on all things voting rights and voter access? Or is it the focus should be on eliminating the filibuster?
I think the focus should be on protecting our democracy. We know that January 6th was the opening salvo in an attempt to roll us back to Jim Crow era. We are watching 7 times the number of bills permeating across state legislatures than occurred in 2020 during election year. And we know that the U.S. Senate, much like the U.S. House, has the sole responsibility under the Elections Clause of the U.S. Constitution to regulate the time, place, and manner of elections. That is something that we have to accomplish. It would be best if it was done in concert with Republicans, as we have in times past when we had to confront our demons and do better by our people. And my deep hope is that we can get it done. But I would say that an exemption to the filibuster for the purposes of protecting our democracy is not only logical, it is fundamental to who we are.
Whoa. So an exemption to that rule. So now if they modify the rules, and the Senate's free to do that, right? They can pass their own rules. They can decide how they want to govern themselves. And so if they say, yeah, we just want it to be a simple majority vote for, let's say, voting bills, anything that's on voting, we're just going to have, well, we can invoke cloture with a simple majority vote. They pass that rule. They can get it through. They got 50 people. Kamala Harris comes in, breaks the tie. H.R. 1 lands on Joe Biden's desk. So the question then becomes, can they do that? Can they get the filibuster rules changed so that they can go in and vote by simple majority? Doesn't look like it. Well, maybe yes, maybe no. But here, H.R. 1 can't pass the Senate. So this is written over on the Washington Post by this guy, Richard L. Hassan. He is the chancellor, professor of law, political science at UC at Irvine, author of Election Meltdown. Smaller, he says H.R. 1 can't pass the Senate, but here are some voting reforms that could. So you can read the whole article if you want. Basically, what they're trying to do is piecemeal this thing. They know that there's a lot of just awful stuff in that bill and it's not going to get the votes, so they can break it up and then try to ram it down our throats individually rather than in one big disgusting sandwich. So that'll be fun. But here he is saying not only is H.R. 1 unlikely to survive a filibuster led by Republican senators like Mitch McConnell, he has directed most of his opposition at the campaign finance aspects of the bill. He said it's not clear it could even get 50 votes from the Senate's Democrats and their independent allies. That makes it an unlikely vehicle for convincing Democrats to abandon the filibuster and requirement for voting rights bills, as I and others have advocated. So he's saying that specifically. He's an advocate for this solution. Abandon the filibuster requirement for voting rights bills. Why would Democrats like Joe Manchin and Kyrsten Sinema from Arizona, who say they want to keep the filibuster in place, vote to abolish it for a bill that might not even have majority support? Which is a good question. And, you know, the issue here, somebody put this kind of brilliantly. It's Joe Manchin's a senator. He's a Democrat. Kyrsten Sinema is a Democrat. She's here in Arizona. If they eliminated the filibuster so that it was just a simple majority vote and they didn't need 60 for cloture, then they would be very, very powerful people because they would be the tie-breaking votes, right? If we only need 51, we know Kamala Harris is going to do anything the Democrats do. Kyrsten Sinema lives in a purple-ish Arizona, looking bluer and bluer by the year. Well, if she could be like the John McCain, you know, who kind of, well, I'm going to go with you or I'm going to go against you, and sees a lot of power. So could Joe Manchin. So why wouldn't they want that? Well, because that's a lot of responsibility that comes with that power. Now they're going to be under the gun on every single vote that comes up. And if they don't side with one particular side or the other, then they're going to get scapegoated for not passing the bill. So on every single bill that comes up, do they want to have to make that decision, or do they just want to kind of hide in the majority where all of the other Democrats are? And so now if it's 51 to 49, they don't have to make that tie-breaking decision. They just go, oh no, we're going to keep the filibuster in place, and we couldn't break the filibuster, so therefore we can't vote on it. In other words, they can only go and vote on the bills that are very popular, that have majority support to end the filibuster. So it's sort of it's very nice politicking. Let's just leave it at that. All right. And so Kyrsten Sinema, by the way, is getting a letter. She got a letter today from the Office of the Attorney General from Arizona. A guy by the name of Mark Brnovich. He sent this letter over to them. Not going to read through the whole thing. I just want to sort of show you what's going on here. So this is a letter from his office, the Office of the Attorney General from the state of Arizona. And you're going to imagine, I know this is Arizona, but you're going to see other attorney generals who are taking more of an active role in a lot of this federal litigation. We're already seeing this. We talked about this previously about Ken Paxton over from Texas, joined on, I think, a dozen or so-ish other states have joined in on that litigation, challenging Joe Biden and some of his immigration policies, specifically relating to the public charge issue that we talked about. And so attorney generals now are sort of getting active. You're going to see a lot of Republicans who are saying, well, we're just going to get involved in this. They're always involved in politics, but they're taking more, this is a state attorney general who is talking about federal legislation, and he's sending a letter to the federal senators of our state. So let's dig into it. He says, letter in opposition to H.R. 1 for the People Act of 2021. Mark Brnovich says, Dear Senators Sinema and Kelly, public servants have no duty more sacred than protecting people's right to vote while maintaining the integrity of the elections. As the chief legal officer for Arizona, I respectfully urge you to vote no on the companion Senate bill H.R. 1 for the People Act, because it would not expand Arizonans' right to vote, but only eviscerate the integrity of Arizona elections and undermine voter confidence, which is, we don't want to do that, because in 2020, we had 100% voter confidence and 100% integrity-based elections. We know that because that's what we heard from Jake Tapper and many of his kind throughout the media for a very long time. Anybody who said that there were any problems with the election, those are just baseless claims. There's no ground for that. No court of law in the whole history of the universe has ever found any shred of evidence that there was any problem with the 2020 election. So I don't even know why we're even talking about voting rights, because our voting system is perfect and there's nothing that we need to change about it. But Mark Brnovich is also concerned that if this passes, this could undermine voter confidence. And we're already at 100% voter confidence in this country. So I agree with him. We shouldn't do anything that undermines it. For decades, Arizona has enacted common sense and commonplace laws to not only expand opportunities for people to vote, but also maintain the integrity of our elections. He calls it laboratories of democracy. We've talked about that previously. Arizona has established election procedures. Notably, most of the provisions of the act seek to expand voting opportunities. They're already available in Arizona, so you don't need to pass H.R. 1 because we already have those here. Arizona makes sensible use of technology by mandating auditable, durable, and voter verifiable paper ballots used in conjunction with electronic voting systems. So you don't need that in the bill. Provisions of the act would invalidate several of Arizona's common sense election integrity safeguards. We don't want to do that because we had a very safe election last time. Further, one of the 5 sturdy pillars the commission identified as necessary to quote, increase voter participation and to ensure the integrity of the electoral system included use of photo voter identification. In fact, the commission noted that an electoral system cannot inspire confidence if no safeguards exist to deter or detect fraud. And so basically, the provisions of the act would conflict with Arizona's statutory requirement that voters present ID. We have voter ID here, and what this act is trying to do is to basically eliminate the requirement of having to have photo ID. The act would also eliminate common sense tools to maintain voter registration records, including preventing election officials from moving voters to an inactive status. And so this is an attorney general who's making these claims. Okay, this is not some blogger. This is not me on a YouTube channel riffing about how awful H.R. 1 is. This is a state attorney general who's saying, listen, this is a problem. Here's why. We'll see if it falls on deaf ears or not. In addition to regulating election administration, the act would also establish a new comprehensive set of campaign finance laws. Finally, a constitutional amendment adopted by voters in 2000, Arizona has utilized 5-member independent redistricting commission. The act would require the state to utilize a 15-member commission for drawing congressional boundaries. Unless Arizona's constitution is amended to update it, well, you can't do that. Public officials, there is no higher priority than maintaining elections. Very foundation of our nation. We have laws in Arizona, blah, blah, blah. Let's keep it that way. Respectfully signed off on by Mark Brnovich, the Attorney General, and he is citing sources. You can see that. Look at all these footnotes here. H.R. 1, Section 1903, H.R. 1, Section 1201. We've got ARS statutes, Arizona revised statutes, and on and on and on. So a pretty nice systematic paragraph by paragraph takedown on it. I'm not going to read the whole thing because it's a big, long letter. But if you want the slides, you can grab those and read it yourself or go find it. Just Google Mark Brnovich. Very good letter. Is the filibuster going away? We don't know if it does, or if they can carve out that exemption like Stacey Abrams wants to do, then certainly they're going to try to pass this. But Mitch McConnell, who is now the Senate minority leader, he's the Senate GOP leader, let's say, and he is unhappy about this threat of potentially ending the filibuster. He offers a scathing, scorched earth filibuster warning. This comes over from The Hill, written by Jordan Carney. Senate GOP leader offered a scathing warning to Democrats amid growing pressure to nix the legislative filibuster. Let me say this very clearly for all 99 of my colleagues. Nobody serving in this chamber can even begin to imagine what a completely scorched earth Senate would look like, McConnell said. He added that in a chamber that functions on day-to-day basis by consent, meaning all senators sign off on an action, quote, I want our colleagues to imagine a world where every single task, every one of them, requires a physical quorum. Cocaine Mitch is back. McConnell's remarks come a day after Senator Dick Durbin, the number 2 Senate Democrat, offers a scorching rebuke on the 60-vote legislative filibuster, comparing it to, quote, a weapon of mass destruction that was holding the Senate hostage, is what he said. These people nixing the legislative filibuster or reverting it back to a talking filibuster, which would force senators to physically be on the floor, has momentum with outside groups and Democratic senators. Senate Majority Leader Chuck Schumer, hasn't tipped his hand on if he supports it, and Democrats don't currently have the votes to invoke the nuclear option to get rid of the filibuster on a party line vote. Joe Manchin, Kyrsten Sinema are both on the record opposing it, and others are viewed as wary. Both supporters of invoking the rules change argue that with the 60-vote legislative filibuster in place, many of President Biden's big campaign promises are dead on arrival in the Senate because they need the support of 10 GOP senators. McConnell warned that nixing the filibuster would not result in a fast track for Biden's agenda, but instead would spark more gridlock with Republicans, voting to cause big headaches for Democrats on even the most mundane of Senate tasks. He says, quote, the last quote of this segment says, so this is not a trade-off between trampling etiquette and then getting to quickly transform the country. That's a false choice. Even the most basic aspects of our colleagues' agenda, the most mundane task of the Biden presidency, would actually be harder, not easier. So, Mitch McConnell, sometimes he can be like a little bit like a turtle, little turtle Mitch, and then other times cocaine Mitch. And I say both those things lovingly, okay? I didn't invent those terms. I'm stealing those from other people and incorporating them. Cocaine Mitch, go get him. Don't end the filibuster. You're not going to like Mitch McConnell when he's angry. Nothing's going to get done in the Senate. All right, first question over from locals.com. We have a Watching the Watchers community over there. If you want to go ask a question and join and support the show, it's a great place to do it. Question comes from Ma Fox, says, the American political system was constructed on the idea of compromise, filibusters, and the status quo. This seems mildly unconstitutional. It's a product of the American version of federalism and a means to stop the tyranny of the majority party. Yeah, it's a great point, Ma, and I think it's very short-sighted of the Democrats to do it, and you can understand why they want to do it on one bill in particular. It's the voting bill. Why? Because voting is so important. If they get that through, then they know that they're going to be able to control basically the election systems indefinitely, which is going to give them the ability to continue to win office, and that will continue to support their power, essentially. So they're okay just with that little exception because they know it's going to lead to a bigger victory down the road. But this has happened before in the past. And there's good argument that Mitch McConnell, when they dropped this rule down from the 2/3 down to the 60, that he was, I think he told at some point, they made an exception to judges. And they didn't need, they basically removed the filibuster for federal judges. And as soon as Harry Reid left the Senate, then Mitch McConnell came in. He became the majority leader and filled up the judiciary with a bunch of judges because the Democrats lowered the threshold for invoking cloture on those judges to serve them temporarily. But as soon as they lost control of the party or of the Senate, then a different Senate majority leader came in and commandeered all of that and used their own rules against them. And so, this is, I think, not a good development. This is not good for the country. I think that there should be some consensus. We certainly don't want every time that there is a change of the balance of power in the Senate that the new party just goes and passes new voting rules. Okay, what happens if in 2022 Joe Biden and his people are punished at the ballot box and the Senate goes back to the Republicans? Are they going to pass another voting rights bill? Are they going to, or let's say, because Joe Biden would still be in power, so he would be able to veto that bill. But what happens when the Republicans have control of all three houses, the White House, House of Representatives, and the Senate? What happens then? It's not good. I think we do want some consensus and some agreement. I agree with you, Mom. We have Dr. Renal MD says, Robert Barnes, I'm going to be on their show tomorrow. During formation of our country, there was considerable fear of tyranny of the majority. Yeah, and I think Alexis de Tocqueville talks about that. This is why the time, place, and manner of federal elections are set with state legislatures. I don't see how it's constitutional to pass a regular law to override this fact. Basically, they want to legalize mail-in voting. Voting is a responsibility. It requires research and shouldn't be like sending a text message. I agree with you. It's an important thing to do, which is why when we have the debate about voter integrity versus voter enfranchisement, or they call it voter suppression, the other side calls it voter fraud. We're sort of on two ends of the spectrum here. But I think that maybe we should focus a little bit more on making sure people who are who they say they are and requiring them to vote in a way that we can have credibility in our elections. Because when we don't have credibility, you have half the country that is still kind of just checked out as it comes to politics. And the country, I think, is not in a good, healthy political state at the moment. We have News Now Wyoming says, I wouldn't be surprised, but just like packing the court, they have to realize how stupid it would be for them to end the filibuster in the long term. Yeah, it would be very stupid because the Republicans at some point will seize control and they can just, do the same thing. And we don't want that necessarily. I don't. We have NY Renal MD says the Dems have 50 plus VP majority. They are proceeding like all Senate proceedings on agreement. If McConnell puts unanimous consent, the Senate would grind to a halt. Yeah, and he's threatening that. I mean, outright. Oh, you need some new copy paper? Okay. Well, let me go see what my Republican colleagues have to say about that. Chuck. Oh, you want to expense that lunch? Not going to happen today there, buddy boy. Because Cocaine Mitch is in town. Not getting that one through. We have Nadarb Lassir says, do you know how close Stacey Abrams was to winning her election for governor? Yeah, I think it was extremely close. All right, I'm gonna put it up. But I didn't put it in the slide. Miss Faith did blame her. Here it is. She was this close. How close was Stacey Abrams to winning her election for governor? About this close. Really, really close. It was really close. And let's move on past that one. All right. So this is, thank you for your support on locals.com. Thanks, Nadarb. Oh no. I have one of those too. You notice that? I got a little bit of one. It's all right. That's why we can make fun of each other. We both have that little tooth gap there, and it's kind of endearing, people say. All right, so we'll leave it. Look, All right, let's move on. All right, everybody, thank you so much for supporting the show at locals.com. All of these tremendous people are helping to keep things on the track for us. Liberty or Death is always in the house. Thank you to Ma Fox, and thank you to Miss Faith Joy for helping us keep things rolling along. We got Lady Anderson in the house, who is also supporting us. By the way, head on over there. This is the address down at locals.com, watchingthewatchers.locals.com. Go check us out over there. We have Sasha Sisha, who just joined up. I think that's going to be down over here. Yeah, there it is. So Sasha Sisha signed up. Baldman, welcome to the show. We also have Leaf45, who joined in. Yesterday, we had a handful of new people sign up as well. Ginny, Realtor Patty, Canadian, Kelly D. Stu, and others. Let's go back and say hi to Dangerous Freedom. We have Jax842. We've got Gust Click. We have CA Java Bean. We have over here Molly May, Paula MK85 in the house. Saw her today. Matt Maker, Jenny, Virginia Mary, and many others. Everybody, thank you so much for your just tremendous love and support over on that platform. If you're not already over there, go check it out and get a couple of great things over there. First and foremost, a free copy of my book. It's called Beginning to Winning: How to Fight Your Case and Succeed in the Criminal Justice System. It's mostly about the law, but you can see a little bit about me. I talk a little bit about my how I got here and why I do what I do. So go check that out if you want to see it. We also have PowerPoint slides that are available for you. Impeachment party documents. We're sort of past the impeachment stuff, so we're going to have to figure out what to put in there next. Copy of our existence system, so a little productivity development process that I do every single day. It's been very helpful for me. You can go check that out. Links and conversation, and of course, all of the great people are over on locals.com. And before we get out of here, I want to remind you, I am a criminal defense attorney. This is my law firm right here, R&R Law Group. We are based in Scottsdale, Arizona. We offer free case evaluations. We love to help good people who have been charged with crimes find safety, clarity, and hope in their cases and in their lives. We are very passionate about what we do. We can help with anything. Anytime anybody's been in trouble with the law in the state of Arizona, we're ready to rock and roll on those cases. So it can be anything from DUIs, domestic violence, drug offenses, any type of major felonies, minor felonies, some of the more gruesome crimes we've helped with, some of the more minor stuff like traffic violations. We can help you clear up an old record. We can help you remove a mugshot off the internet. We can help restore your rights so you can go and possess a firearm again, go and vote again, be a full citizen. We can help with all of that stuff and more. So if you know anybody who happens to be in need of those services, we would be honored and humbled if you sent them our direction. We'll make sure that they leave better than they came in, and we're pretty good about what we do here. We're very passionate about it. Awesome team of people, and so we would be humbled and honored, honestly, if you sent people our way. We'll make sure that we take good care of them. And that is it from me, everybody. We are going to hop on Clubhouse. I have about 30 minutes this evening, so we're going to spend about 30 minutes Q&A discussion. If you have any questions, it's a good place where we can communicate, kind of see each other's pictures and then hear each other's voices. The link is in the description below, so sign up on there if you want. If you need an invite, send us an email to tips@rrlawaz.com. Miss Faith, I don't know if she has any invites left, but I do certainly. So send us one. We'll make sure we can get you on there. It is only for iPhone and iOS devices right now. So if you're an Android user, you're kind of left out. And I'm an Android user. I know it just stings, but this is what we got to work with. I know that Twitter and I think other platforms are building sort of competing platforms. So this will be available in the future for everybody. At some point, we're just not there quite yet. So if you want to join us on Clubhouse, I would encourage you to join the club as well. There is a Watching the Watchers club over there that you can join. We're going to hop on there and have a conversation. I want to invite you to be a part of that. Otherwise, we're going to be, we're not going to be here tomorrow. There is not going to be a show tomorrow. Do you know why? Because at the same time, we're going to go over to Viva Frey. We're going to go over to his channel and talk to him and Mr. Barnes. They have a new show where they're interviewing people on Wednesdays at the same time, 7 p.m. They're trying to counter-program us. That's all right. We're just going to go right on their show. How about that? We'll just take it over for a day. So I'm going to go on there, and I'll be interviewed there. We will share the link to the show tomorrow. So we'll post that in the community tab. We'll post that on Locals. I'll post it on my socials and on Twitter and everywhere else to find it so that you can go and join us. So it'll be a little bit of a different night for us. They have great content, by the way. If you're not already over there, I would encourage you to go and subscribe. Very good stuff. Robert Barnes can talk circles around almost anybody. Viva's very, very nice guy, very insightful. And so I'm looking forward to speaking with them, and I hope you will join us. So that is going to be at the same time. So it's going to be 4 p.m. Arizona time, which is Pacific time. on the West Coast. Then it's going to be 5 p.m. Mountain Time, 6 p.m. Central in Texas, 7 p.m. Eastern for Florida Man. Everybody, have a tremendously lovely, wonderful night. Have a nice, hearty, healthy dinner. Sleep very well. I'll see you right back here Thursday, tomorrow on Viva. All right, everybody. Bye-bye.